Fulton County Superior Court Judge Scott McAfee has scheduled a hearing today to consider motions from former Trump lawyers Sidney Powell and Kenneth Chesebro to sever their cases. This comes after they pled not guilty to racketeering charges in the battleground state's election interference case.
Joining us live now, senior correspondent John Huddy with the details down there. John, what do you got for us?
Yeah, Bob and Lydia, there's a couple of headlines coming out of this hearing, which is ongoing. That's first that the Fulton County DA's office says that the trial will take at least 4 months and that the state plans to call 150 witnesses. Deputy DA Will Wooten is making the state's case in the argument that all the defendants should be tried together at this point. And this is the first time, by the way, Bob and Lydia, that we're actually seeing the courtroom proceedings live in this case. It's also really the first important test for Fulton County DA Fani Willis and her efforts to try all 19 defendants together. That said, we've also heard arguments from the attorneys for Sidney Powell and Kenneth Chesebro, who are arguing that their clients should have a speedy trial. Only Chesebro thus far has a scheduled trial date, that being October 23rd. Also, their attorneys are making the motion and the demand to sever their cases from the other co-defendants. That said, former Trump attorneys John Eastman and Ray Smith also filed motions to sever their cases from the other defendants. In Smith's motion, which was filed last week, as we reported, his lawyers write the case involves just too many defendants, is quote-unquote Byzantine, that is overly complicated, and then it goes on to read that the court should sever the defendants into manageable groups so the case can be presented in reasonable bite-sized segments that a jury will be able to understand and assimilate in a reasonable amount of time. And then Smith's motion also discusses severing the case and defendants in any case where the prosecutor anticipates that a joint trial will exceed 4 months. So that is what we're hearing from this hearing that's going on right now. Willis, as we know, DA Willis wants the trial for all the defendants to start October 23rd and includes the initial 2 terabytes of discovery evidence. So a ton of discovery in that first batch to go through. And on that line, former President Trump's legal team filed a motion last week to sever his case from any of the defendants, be it Chesebro, Powell, or anybody else pushing for a speedy trial, saying the state's October trial date is just simply unreasonable based on the size of discovery to come through at this point. Tuesday, the state also filed a motion to use a juror questionnaire for jury selection. The motion reading the state requests permission to use a jury questionnaire to aid both sides in the efficacy of jury selection. But that raises another question. How long will jury selection take? It's already been 8 months in another case, the YSL gang trial involving rapper Young Thug, who's also indicted on RICO charges. And as far as the Georgia indictment and the ongoing case, Bob and Lydia, former President Trump in an interview earlier today said that it is absolutely politically motivated and that he called that, along with the other indictments against him, quote-unquote, fake cases. Guys, back to you.
Yeah, John, a ton to unpack there. Great reporting, great explaining, and we're going to discuss this now. Joining us now to sift through everything, former New Jersey Superior Court Judge Andrew Napolitano, Republican strategist Jeannete Hoffman, Trump attorney Jessie Binnall, and attorney Mehek Cooke here, guys. Judge, we'll start with you. Is this normally something that a judge will grant? You know, they want to sever. They say they're not connected, these two, to the other 17 defendants here. What do you think?
There's nothing normal about this case because the lead defendant is the former president of the United States, and 19 defendants in one case is an overwhelming number. But if the case is going to take 4 months to try, there's no way the judge is going to try it more than once. So I don't think the case could possibly go on October 23rd. That would be exquisitely unfair to all of the defendants. It would be nearly impossible for lawyers to review the mountain of evidence that they need to review between today, September 26th, and October 23rd. So that'll probably be kicked off until after the Christmas holidays. But I do predict that we'll see this case tried in a high school gymnasium, because you're going to have over 40 lawyers in the courtroom just on the defense side.
Now, Jeannette, we just got this notice across our news desk. Fulton County District Attorney says that the Trump racketeering trial of all 19 defendants will take 4 months and include 150 witnesses.
That's crazy.
It's insane. How is this even possible? And why lump everybody all in together?
This is crazy. Now, listen, I am not an attorney like the judge, but to me, I mean, this just seems absurd. And if I'm one of these 19 defendants, I'm having my attorneys make a motion to sever because it's just common sense. It's just due process. These claims for all these defendants, some of them are completely unrelated to the defendant. So to me, this just seems like a complete circus. It seems politically motivated, and it just seems unfair and a weaponization of the justice system that we've seen time and time again connected to the former president.
Absolutely. And Mehek, Willis initially wanted this trial to begin on March 4th. That means, based on her office's estimate, the trial would have stretched into July. Why the rush? Why do you think she's trying to rush this case?
She's trying to rush this case because we have a leading presidential candidate that is being charged by this district attorney. It is politically motivated to discredit our Republican nominee right now. And also, I think it's very interesting. Every time we have evidence of Hunter Biden's, whether it's corruption, conspiracy, bribery, tax evasion, suddenly we have charges against our former president. So she is truly trying to rush this case because she wants to ensure that President Trump does not have key votes in some of the key early states, New Jersey, New Hampshire, Iowa. This is all politically motivated, and they're tying it to our election schedule. It's unfair, and truly, to receive a fair trial, we need to ensure that each one of these defendants have separate trials because they're going to find that there's no conspiracy, there's no collusion. RICO is meant for mafia style activity, not what the former president done. We need to start looking at Hunter Biden and his family.
All right. Jesse, we didn't forget about you. We have a big panel here, a lot to discuss. What's President Trump? What do you think his camp is thinking of? Should they maybe make a motion to sever? How could he possibly get a fair trial? He's the former president of the United States. How could this possibly be fair to him, lumping him into everybody?
Well, let's just start with the real obvious thing here, and that is this case should never make it to an actual trial. This case should be dismissed out of hand because what she is effectively alleged is a conspiracy to engage in First Amendment protected activity. That's not just the freedom of speech that we all know about, but it's also the right to petition your government for redress of grievances.
Jesse, we're going to leave it right there. Sorry to interrupt you. We want to take a live listen right now at the Fulton County Courthouse. Please, Jesse, just stand by. I'm sorry about that.
Joinder is authorized. That doesn't mean that severance is inappropriate. Those are not the same thing. Just because joinder is authorized does not mean the court shouldn't sever. Let me be clear about something, Your Honor. The state wants this case, and I think it's absolutely clear in the pleadings. The state wants a case against Donald Trump and all these people together. The state wants to make this case about Donald Trump. Donald Trump is one of 19 defendants. Ken Chesebro is another one. Ken Chesebro is not a politician. Before 6-7 months ago, he was probably unknown to 99.9999% of the population. You get all those nines? And so now to force him to sit here in a trial where there's evidence of all these other things is just not fair. And I'm sorry, Your Honor. You know, they have a slide here. RICO is different. Sure, it's different. I acknowledged that in my opening. But what this slide does not say is that RICO overrides the rules governing fundamental fairness, constitutional and statutory protection that are designed to protect defendants. This Willingham case, and upon information and belief, I believe most of the other cases cited by the government are cases like murder. The Willingham case is a murder case. It's a murder conspiracy case. Certainly, the state understands the difference between 3 and 4 people being charged with one single conspiracy versus 19 people being charged with 3 or 4 different conspiracies. And, Your Honor, if the court were to take the state's arguments at face value, there would almost never, if ever, be a RICO case that can ever be severed. And think about what that means. It means that the state of Georgia and the various district attorneys throughout the state can use the RICO statute, can take 3, 4, 5, 6, 7 different conspiracies, and at their sole discretion, with no oversight by any court, say that they're one, bring them in one indictment, and then we're all stuck together. And quite frankly, Your Honor, let's compare and contrast this to the YSL case going down a few, I don't know if it's floors down or up, I think down. That YSL case, I don't know much about it, but I know enough. I've watched it TV, listened to podcasts. It's a common conspiracy. Yeah, there were different overt acts being done towards the same conspiracy, and therefore the state can try them together, but it's one conspiracy. And that's where I think if you read that Willingham case, where there is sufficient evidence of a common scheme or plan, how, Your Honor, is the plan down in Coffee County, if it's a plan, the alleged plan, have any commonality other than electing Donald Trump, Your Honor? Half of the United States took some act towards electing Donald Trump. If that were the only thing that mattered in terms of connecting all these as a common conspiracy, there would be no rules of due process. And the last thing I'll say, Your Honor, is I will go back to what we said at the beginning. I think it's perfectly clear here that this trial does not have to last 4 months. Because what the state is assuming is that, let's say, Your Honor grants our severance motion and allows us to try our case just Chesborough and then Powell separately. Well, they're saying, well, it's all going to be the same evidence. Not necessarily. Obviously, the time hasn't come to file motions in limine, but we will obviously file motions in limine regarding the admissibility of certain evidence, certain extrinsic evidence of other acts that we don't think are relevant. And we have the other motion to sever the counts. And no one motion, I don't think, Your Honor, should be, they all, obviously, I know the court has to rule on all of them independently. But I would argue, Judge, that you should consider them jointly.
Okay, right now you're listening to attorney Scott Grubman. He represents Kenneth Chesbrough. Right there, he's asking Judge Scott McAfee down there in Georgia to sever Chesbrough from the case, meaning he wants his own separate trial, claiming, you know, how could he possibly get a fair trial being lumped into all those defendants? Jessie, I want to go back to you. We had to cut you off there before we dipped in, so finish your thought there on President Trump's take and what you guys think, but also reaction to what you're hearing down there in the courthouse in Georgia.
Yeah, so, I mean, it's I think when it comes down to it, this is a prime case where the case should be dismissed before trial because it's all about First Amendment protected activity. And that's what you started hearing, I think, a little bit about from Ken Chesbrough's attorney there in the courtroom, talking a little bit not about dismissal, but about severance. And that is something that I think is there's going to be some important issues with severance for everybody's right to have a fair trial. I think that's especially going to be important for President Trump, because one thing you have to remember about all this is President Trump has effectively been charged with listening to his lawyers, with taking legal advice from his lawyers. That's something that every American has a right to do, to go to their lawyers and say, what are my rights here? And so I think that the cases should be severed. I think that the fact that they want this case to take more than 4 months and they want it to start ostensibly in the spring really shows that Fani Willis's primary motive here is to take Donald Trump off the campaign trail. Absolutely. And so, yeah, that's what this case is about. The American people know it. It's about the 2024 election.
And I think she was trying to also fundraise off of this because she actually put out a website, too, to try and raise money. So clearly,
she campaigned on it.
Yeah, political persecution, election interference at the highest level. Jessie Binnall, Mehek Cooke, thank you so much for joining us.